Welcome back. You're watching Cheche with today's guest, Ibrahim Wasane, who's the chairman of the board of the Land Development and Governance Institute, and Jared Opio, who's the Ford Kenya Member of Parliament for Awendo. We've been discussing the various bits of land legislation floating around, some of them tabled before the National Assembly. We've talked about the pros, the cons. We've talked about the fact that there might be political mischief. Mr. Wasane, do you believe there's political mischief?
I was making the observation that part of the reason that I think there's been a lot of anxiety and speaking out against the bills, from my perspective, is I explained at the beginning that there were three bills: historical injustices, evictions and resettlement, and maximum minimum, which were collapsed into one. The omnibus bill. And you see, this is the chemistry. When everybody has finished up with the process, they throw them at the highest state organ, the cabinet, which then brings back a bill which goes to parliament. Now remember, there's never a window for that to ever be validated by the parliament. It just goes expressly to parliament, and then our representatives have the opportunity to then engage that framework. Now the fact that the historical injustices bill reappeared as an amendment to the National Land Commission Act, the maximum minimum bill reappeared as an amendment to the Land Act, and the evictions and resettlement bill reappeared as an amendment to the Land Act. It's certainly in very shrunken form. Would make even the membership of those task forces begin to ask, so what happened? Why? And also the fact that in shaping the amendments to the existing laws, the clauses that were causing conflict, which were essentially giving powers, technical powers to the Land Commission, have reverted to the ministry. But remember, as I say that, I said an objective reader, before you form an opinion, needs to read the land policy, the constitution, then those specific sections, and ask the question, did the constitution intend to give those powers to the commission, or did it not? Then you can be able to have an objective discussion. David, you've read these documents, but the sense I get from you is that you do believe that there is political mischief. Am I wrong? Is that an unfair assessment of your position?
There is an invisible hand somewhere that is stopping this country, in my view, from moving forward with comprehensive land reform, so that, you know, some of the rigidities you're seeing there, some of the attempts to switch authority from the constitutional bodies like National Land Commission and vest them back in the institutions or ministries of national government like lands, and recreate, you know, registrar, reinvent the registrar, I mean, from the Commission of Lands, so that they are having more powers than the National Land Commission. It seems to me like the attempt by the national government still to hold power back to itself, from sitting out to where the Constitution sent the power to, so that the land reform can move.
If you look at the history of Kenya, you look at the history of Kenya, the president from Kenyatta to Moi to Kibaki, all of them were given land through the Commission of Land or the registrar. It was a way of rewarding people. People used to search titles. Where there is PDP, you say this is empty. In fact, it is said that even Moi sometimes signed off his own land without knowing. So that entrenchment is there.
Yes.
And it is not going to move.
Would you call it vested interest?
Yes, vested interest. It is not going to. In that, who is in that cabinet? Most of those people in the cabinet are people, either they have the land or they aspire to have the land. So when you tell the governor the community land, I think governors can now control that. What about the people? Where will they get something to be?
In fact, one of our viewers was asking the question that what if the people who are entrusted with these community lands sell it off?
Yeah. Odwak, that was the $1 million question. It is, we need to be very careful investing community land, not to give it back to the framework that undermine communities. Remember, our local authorities, David, in the past, everywhere around the country, used community land, which was then trust land, to really take land directly to themselves or their friends. Now, let's please remember.
If you look at Moya, because I used to live in Embu, Moya trust land, it has been given by 3 pieces, by 3 layers. 3 people given one piece. That happens all the time.
Yeah. So that is why I'm very concerned, and a lot of stakeholders are concerned that power to deal with that land should not be with the National Land Commission nor the county government, but with the communities. You know, some institution of the community to take care of their land. Now, I think that's why I say that's $1 million question.
Again, that is a very difficult route to take, because when do communities find consensus? In which forum? The law proposes they can form societies to own that land. Look at the controversies in those communities. As Mutegi points out, in some of those areas, communal land was appropriated by individuals. This law makes it almost obvious that people will begin redrawing the extent to which their community land went and try to get it back against the private owners who acquired it through fraudulent means or political connections.
Welcome to the challenge. So what would you propose? And that has been the question I've been trying to draw all of us to. Please propose, and everybody who looks at that framework, because I have looked at that framework, I know there before we had something we were calling community land boards, community land management committees, community assemblies, a fairly elaborate framework. Yeah. Now, if you actually had seen that framework, I then can see you would even be more angry about that proposition. So the challenge to the county governments and to members of parliament is to enrich what has come on that bill and create a framework that we think can protect community land.
My view is this, Madane. The National Land Commission, which is charged with the responsibility of managing county land, community land and public land on behalf of the national government and the county government, should just be given back its mandate. Then using authoritarian powers vested on it by the Constitution, the way we gave IEBC mandate to redraw boundaries and sort out those things, go around identifying community land, isolating it, and then bring back to the country or to communities. This is where it goes up to. Because if you say, send it back to communities or counties to sort out, there will be chaos.
I wish that went on record for Parliament. You will see the reaction from the community.
You were nodding your head, actually, when David was making that point. What do you think?
No, but to come back to his earlier point that he sees some invisible hands in this whole matter, I think I agree with him very much, because we know very well that the process of generating these laws is that after those public hearings and all that, they go to the cabinet, where then they are presented to Parliament for engagement. And we are aware that the cabinet has got people who are actually the landowners in the country. They would be very, very apprehensive about a comprehensive land reform that is likely to either claw back some of the land that they have, or maybe not take care of their interest or the interest of the lands that they acquired irregularly. But having said that, I think the matter of community land is a very delicate matter, because we must be sure that these are trusts, these are organizations that are mandated to administer and run and determine the way the community lands are used, are not in a position to mortgage those lands without the knowledge of the community. So in drawing that the law that will govern that, we must make sure that we take the interests of the community so that they are not shortchanged, just like they were in the global.
Can we see the National Assembly taking it upon itself to draw up laws that give effect to the Ndungu report?
Yeah, and that's why I'm saying that we need not
reinvent the wheel.
Yes, I really wonder why we had to collapse the three bills into this omnibus, because the omnibus is like an amendment to the existing land law, and it has, for you to understand an amendment bill, you must take the parent law and then you take the amendment itself. So you read this and you read that, so that you consolidate your thoughts. So the government has got this, or rather the executive has got this habit of sneaking in bad laws through the omnibus, because it's like members, unless they thoroughly interrogate it, we are more likely to pass a law without properly interrogating. That's why if it comes in as a standalone bill, it is more easier to read and understand.
I mean, part of the problem of the omnibus bill is that it restores the powers of the Commissioner of Lands, and it also proposes to overturn spousal rights and customary trust land rights caveat.
Udwaka, before I comment on that, allow me to point out one thing that keeps coming up. The Dongo report is actually continuously assimilated in the process of the National Land Commission reviewing grants to public land. If you notice in the recent plan, and we must commend the Commission on that particular account, they've done well in terms of looking at grants of land that were earlier irregularly allocated. So the Dongo report acts as a mirror. Remember, it's not necessarily a legal document, but they do borrow from it, I know, because if you look at the kind
of...
But
the point is that can we not make this a legal document?
If you ask a number of people, they may tell you you need to be a little careful, because some of the properties that were named on that report are not necessarily irregularly acquired. So you need to have a very careful lens if you're using it. Yes, there are some that certainly belong to that category, but then you could easily find that some will kick very hard because they can prove to you that they didn't. So one needs to use it carefully. So and as we proceed, it's good to point out that those powers of the Commission certainly are still intact. So we haven't lost that. Now, in regard to the spousal rights and customary trusts, I was actually speaking to somebody from the Law Society of Kenya yesterday, because they are the ones who moved in that task force that I mentioned. They are the ones who moved amendments to the bills. And I asked him, so why did you then handle this? And he had a long explanation, fairly intelligent, that look.
Let the public judge that.
Yeah, and they bounced that to the public in the forums that they went to. And this is what an overriding interest is. It's an unregistered burden on title. Now let's take spousal rights for instance. Now, you witnessed situations whereby when somebody passes on, you are several people bouncing in and saying, we belong, we have rights. Now, when you name spousal rights which is not specific and make it a burden on title, what is likely to happen is that if the owner of title passes on, you could have 4 or 5 people bouncing up and saying, we
actually, there are several viewers talking about being in polygamous context and being denied inheritance rights by this wife or that person or this person or the other person. What recourse do they have then within these proposed?
So that amendment contains a second subsection which allows the registrar to actually note interests that are clear. So if you feel like you could be a subject of a multiple interests, that some of which are not legitimate, you could then record them on the register, so that if David wants to buy your property, he is fairly specific that he has to deal with spouse so and so, or 2 spouses so and so and so and so. Not a vague situation whereby 5 can spring up finally and say, although you bought that land, I own. Right. So a lot of this went through a lot of professional discussion before the amendments were floated. I think it's important to appreciate that point. And I think for members of Parliament, particularly the Committee on the National Assembly, the Law Society Committee and members of that task force are available to clarify some of these clauses. And they were in Mombasa. They spoke to the reasons why they did so.
Okay. We've got very little time left. I want to get your response to a specific question situated within polygamy. My dad has 2 wives. My mother's the first one and she's dead. We asked our dad to give us our share. Our stepmother refused. We went to the chief, went to the DO, but nothing was done. We put a caution which was removed. What can we do now because we're in great poverty? Please help us. And this came from Gladys. And there are several other viewers in that sort of situation.
They just need to prove their interest, and that is going to be discussed through a legal process. Most likely, if they have the facts, they'll get their interest.
There used to be a institution called adverse occupation, whereas if you occupy somebody's land, he has not been there for 12 years, I think it was. You can't now come and say, oh, this is my land. Why were you 12 years ago? Is that situation the same way in this bill?
Adverse possession is not part of the Land Bill. It's on the Limitation of Actions Act.
Yes.
It's still adverse possession. It's part of the Limitation of Actions Act, and it's still there. If somebody sat there for 12 years on end, they're going to claim right.
So you want to wait
20 years. They'll claim rights to that land. One is for easement, one is for ownership. But then you go to a stuck there uninterrupted, looking like you've been allowed. If there has been a contest on those rights, you cannot use adverse possession. If Mheshimiwa did not allow you and he found you there and told you to move out, then 5 years down the line you're not moving out. You cannot count that as part of the term of years that you're going to use. So it's quite complicated to prove it. But I think listeners and viewers need to be conscious of the threat of adverse possession if they do not police their boundaries. And
one of the things that I think your institute is suggesting is that the government engages law students to help squatters prove their case.
Yeah, there are organizations that are pro bono, legal organizations, so people feel like they have a case for adverse possession. Somebody called me just the other day and they wanted to move their case, and I warned them about the technicalities so that you don't then lose too much money if you do not qualify.
But why is there fear for the maximum in the way you see it, acreage? Well, I mean, people have huge chunks of land across the country. They're not going to be dispossessed of the land by fiat, by order. There will be a compensation mechanism, isn't it?
I say the fear for the minimum maximum is at two levels. The first level, the small sizes, because there are many in this country.
Yeah.
And the moment you touch them, you ask Mheshimiwa the kind of war you will be getting. I remember in the forums we've had with members of parliament, that is what concerns them most.
Yes.
So they will fight because they are asking you, so what will we do if we cannot subdivide our 4-acre parcel of land into our 5 sons and get title?
And daughters.
Yeah, and daughters, thank you. Then on the higher level, you've been talking about that several times. There are lots of people with fairly large parcels of land. Some of them bought them off the market legitimately. So you talk about that and they're asking you, so what do you mean?
In other countries,
they can require to sell the land
if the land is not used.
Be compensated.
If the land is not used, probably the government should have a policy where the land is not used, then tax it.
Exactly.
Yeah, but they don't want to pay tax.
We've been advising that's probably the best way out of this.
It's on the table.
Tax what is not being used.
Yeah.
Graduate the tax so that gets high, gets painful. You flow to the money.
You dispose it.
Yeah. That's an easy.
That's what happens in the rest of the world.
Okay, so we've got to wind up now. Sir, I'll just ask you to enlighten us. Where do we stand on these bills? They were tabled, they're before the National Assembly. What should we expect in terms of timelines?
Yeah, once legislation comes to the House, they queue. There's a conveyor belt, and it has to go through the process. Probably the only organ of the House that can hasten or rather determine the speed with which they move is the House Business Committee. So in their own wisdom, they'll see how to roll them over to us. But I think by the mere fact that they are on the order paper, it's not a guarantee that they'll be discussed anytime soon, because sometimes other businesses come and take precedence. So I think, but we are hopeful it will come and we'll give our input, however controversial they may be.
Okay, we had a comment from a viewer, and I think Mutegi was making the point earlier, that public participation does not end with task forces going round and soliciting views, that what you come up with must then return to the public and must be validated. Given that we have these pieces of legislation before the National Assembly, does that mean that the public can no longer input into the legislation? Can we still find ways and means of correcting them, giving Kenyans the best laws possible?
I remember when we were in Mombasa, when that issue of participation came up, the chairman graciously said, look, stop complaining about participation, give us your input, we shall accept it now. I don't know, Mheshimiwa, about the order of business, but I want to believe that as you go into the discussion stage, and I thought we can make use of that window. If I was able to get my member of parliament to pick up a point that I feel has been left out and is useful in improving the bill, I can still pass it on to them and they can lay it on the floor of the House and can inform the final bill. Is that true?
Even in the form of further amendments.
Yeah, so Udwak, my plea to ask Kenyans is that these bills, in my view, are not perfect, but they are a fairly good start to a problem that we must resolve. we can use the framework within Parliament, the infrastructure within Parliament, and our MPs now, because that matter is already before Parliament, to improve the sections of the bills that we feel unfit.
How do we ensure that it's not elitist, as the MP?
In fact, the Heshima should go back to their constituencies and hold forums and educate people on this law and seek their opinions and say, look, this law provides this. This is what is going to happen if this law passes. What would you like? What do you think? Is that okay? Then they pick those suggestions and bring them back to the House in the second reading.
And colleagues.
Yeah, that's what I was saying about our public participations that we've been holding. I'm saying they're too elitist. And because you call a meeting in KICC or in Mombasa in some hotel, and you really believe that the villagers have given their input. These barazas, as he's saying, are the best because you collect raw information. They could be in whatever language, in a crude form, but they could be brought, they could be processed and then made to add value to these bills. Okay, David and Mutegi, final thoughts. Given the fact that there might be mischief, invisible hands, vested interests, do you think that this time around, if we get the public participation right, if we ensure that we're getting the views from every single person, from every community, that we can actually change the course of administering land in Kenya?
I thought the Constitution was written for Wanjiku. Where is Wanjiku here? Where is Wanjiku here? I don't think it will work. There's so much vested interest in land in this country, very emotional, from the very poor to the very rich. So that to get to a consensus is almost impossible.
David?
We need to put our eye on the Constitution in all this legislation. A lot of sneaky mischief is happening, trying to claw back the powers that we devolved from the national executive. We need to watch every legislation whether it's in conformity with the spirit and letter of the Constitution. And a lot in these proposed bills is not in harmony with the Constitution.
Haven't I seen a law today saying that the President will now be appointing the Deputy IG and the things that we remove from him, he wants it back, and the Parliament is going to give it.
Well, our time is up. We won't let you speak on that one. Our time is up, and so we want to thank you for your time on Cheche this morning. That's Ibrahim Wathane, the chairman of the Board of the Land Development and Governance Institute, and Jared Opio, the Ford Kenya Member of Parliament for Awendo. Our thanks also to Mutegi Njau and David Makali, our panelists. Thank you for watching and listening to Cheche. We've been live on Citizen TV. My name is Udwa Kamimo. We'll see you next week.